The hearing starts with a quiet procedural fight, but the real tension is about control. The judge immediately shuts down the defense strategy of slowing the case down through a continuance request. That matters because courts hate the appearance of tactical delay in emergency family hearings, especially when temporary restrictions were entered without a full evidentiary review.
Ms. Chrisman respond, and we'll kind of see where we're at and how far apart you two are, and how close you might be in resolving a lot of these matters to just formalize the divorce itself.
Judge, I apologize. I hear that you're instructing petitioner to proceed on her motion. I had emailed the court yesterday. Basically, I didn't file an entry of appearance until yesterday. I was not provided any exhibits from the petitioner. I was just retained Friday afternoon. And so I was requesting like a week or two of a continuance. I understand there is an objection. I completely understand that. I understand that the petitioner has a right to be heard over a motion to modify an ex parte orders. I'm not prepared to proceed. I haven't seen any documentation or anything about the support issues or anything like that. But I would ask the court to consider just a week or two for me to be able to become familiar with the case. I don't want to belabor it by any means.
Right. I'm sorry, but I feel like when an attorney enters and knows there's an impending hearing, they have to make their decision of whether or not they're going to represent based on can they appear and represent the client at the impending hearing and not assume that there's going to be a continuance because there's a recent entry of appearance. I try to do that. I typically do that, but not in cases where it's on a motion to modify an ex parte order that they haven't been heard statutorily as they're entitled to or otherwise. And these were granted without an involvement of an attorney, and I think I need to review them. So that doesn't mean that I won't give you an evidentiary hearing on the temporary orders again if you want a full evidentiary hearing before finalization. But I want to review these temporary orders with both counsel and both parties here briefly this morning.
Certainly, I would just make a blanket objection to reference to any documents I haven't been provided by counsel.
Okay. All right, Ms. Huntington.
Thank you, Judge. Hearing what the judge has said with regard to an evidentiary hearing, the main concern for my client today is getting parenting time resolved. In November, I don't know the exact date, that's when the parties separated. December. My client was having parenting time essentially every Tuesday or Thursday, and then every other weekend. And that continued up until March when this temporary order was filed. The temporary order, Judge, has my client only receiving a few hours one night a week on Tuesdays. That's not consistent with the de facto parenting plan that the parties have followed for months now. It's not in the best interest of the child to only see her father once a week for a couple of hours. Child's 2 years old, as the court pointed out at the outset of this hearing. Having frequent contact with both parents is important during, for a child of that age. I know that the respondent will say, well, the petitioner assaulted me. And there is a case involving that, Judge, and I've watched the video, and I know I'm not the decision maker, the court is. But what occurred was my client appeared for a child exchange, and the respondent tried to climb in his car and take things out of the vehicle. And he tried to pull her out of the car, which led to her calling the police and filing a battery case against him. There is a ring video that shows the incident. I think he's got a first appearance on at least part of that tomorrow.
May 11th.
Yeah, May 11th.
What court is that in?
It's in Butler County.
Is it the district court or a municipal court?
I believe it's district, ma'am.
Judge, you did the first appearance on the first case, but there is a second case.
The second case relates to now allegations of violations of the temporary order. My client believes he may have contacted her over social media. He's very distraught over the divorce in general. And so that may have occurred, but
Okay.
there's no attempts to contact her, come to her house and assault her. There's nothing like that, Judge.
Okay. Ms. Chrisman, what do you believe, based on discussions with your client, is going to be her position as to why he poses a danger or threat to the minor child of the parties?
Yes, Judge. So first off, we're unaware of any overnight parenting time that he's exercised. So we obviously disagree with the de facto. We don't know what his home looks like. We do know that he has made some pretty aggressive suicidal statements. We obviously don't want a 2-year-old to be subjected to anything of that nature. With any DV case, he's going to be prohibited, at least during the pendency, from having any firearms. There are a significant amount of firearms. The incident described, yes, there is a video of him dragging her out of her Tahoe that she has possession of at this time. There was also a severe DV incident in Christmas of 2024. There was a severe incident where my client thought that he was going to kill her, January 25th of 2025. The child was present for that. And then there was also the final incident that's alleged in the criminal cases, as well as continued violations of the protective order that's been in place by law enforcement. My client is concerned with all of these items, and there are oftentimes when domestic violence, when he no longer has his primary victim, it shifts to the child, especially a female child. And so we do have concerns, one, that he's not exercising his actual parenting time. It's grandma. He hasn't had overnight time. We disagree with what the de facto is, but also the suicidal ideations that could occur in front of the child, as well as the firearms as well.
So my part.
All right, what else is at issue?
Well, the other would be the spousal maintenance, Judge, and then my client's access to personal property at the marital residence. He's been unable to obtain those. I had requested in the motion that
The father's side responds by attacking motive instead of only denying facts. That is a calculated pivot. His attorney starts suggesting the criminal complaints may be strategically timed to interfere with parenting rights. That argument is not aimed at proving innocence.
he, with the police assistance, that he be able to go there and retrieve personal items, clothing.
I have clothing, it's just all my other shit.
Yeah, there's a lot of small items, and we could do an inventory and provide that. I do want to say on the criminal case, we've noticed a pattern, and it's a pattern to us. Maybe it's coincidental, but after we filed the motion to modify, there have been no contact between the parties, and the respondent called the police, had the police come out and talk to my client. After we turned over the exhibits last week, she called the police again and had them come out and talk to my client about an alleged incident in November. Judge, this is just escalating into an attempt to prevent my client from having parenting time with the child. I don't know. My client tells me they were doing overnights. That was the de facto schedule. I'm not sure how we can prove that, but maybe my client's mother can come and talk about that. But he does not pose a risk to the child. He has struggled with the divorce, as I mentioned before. He doesn't want it. This is not the path that he wanted, but restricting his access to his child is just adding more just more stress to him, and with how he's dealing with the whole situation, Judge.
Okay, so this is the second marriage for your client, correct?
Yes.
All right, and does he have any children from a previous relationship?
Yes, he does, Judge, and I included in our exhibits, just so that if the court wanted to look at that, he has a parenting agreement with those children. They come to see him in the summer. That they live out of state, so there's some long distance travel there.
Okay, And then this is a third marriage for your client, Ms. Chrisman. She has 2 children from a previous relationship. Is that correct?
That's correct, Judge, and she's the primary custodian for those children.
Okay. And where is your client actually living, Miss Huntington?
South Ohio.
He's in a house of his own now, 227?
So,
127 South Ohio.
Is that in Benton?
yes.
Yes,
Okay. And then she's out east of town of El Dorado. And was that a marital residence there?
yes.
And does that have property with it? Do they own it?
No, well, it's a rent to own situation.
Okay.
And that's the same for my client in his new residence.
Okay.
Judge, I believe the home is just in my client's name, and that predated the marriage as well.
Okay. And is your only, let's see, how much was awarded as maintenance?
It was 900.
900, Judge.
And then what about child support?
That was 1,001, I believe.
Yes. And with regard to the child support, he does pay $1,155 a month to his other, under a separate order for the other 2 children. That's not accounted for in that child support worksheet.
Okay. All right. Well, Ms. Chrisman, it is fairly uncommon not to give a parent a visitation schedule that includes an overnight. And unless there's some allegation of unfitness to parent and folks are asking for supervised visitation, that's generally the restrictive layer that typically occurs. So I really think that he should at least have one overnight. And so I'm not going to go Friday because the age of the child. I'm not going to start out with Friday to Sunday. But I am going to start from Saturday AM to Sunday PM. And that can be 8, 9, or 10 AM, whatever works best for the parties, given whatever schedules they have and other commitments with other children. And then by 6 o'clock on Sunday. And of course, the child needs to be clean and fed by 6 PM so that the other parent doesn't pick the child up or get the child and immediately have to do all the parental duties. So it should entail making sure that the child is clean, well cared for, and fed, and dressed appropriately, etc. I am not inclined, though, to change the maintenance right at this very moment until I can figure out all their financials. And I would assume that predominantly
The hearing then turns into judicial damage control. The judge openly doubts mediation will work because the hostility level is already too high. That is a major signal. Courts only lose confidence in mediation when communication has deteriorated into pure distrust or when safety concerns poison normal negotiation.
he is much more concerned about having contact with his child than how much he's paying out of his pocket. I can't really help that he's got other children that he's responsible to support, but he does get a credit when overall you're looking at the number of family members or children that he is supporting. And so that worksheet ought to be recomputed just based on the fact that the right family number wasn't used. Usually that doesn't make a tremendous difference, but it may make some. And then I'll go ahead and sign a new worksheet for that. But I'm not going to modify the maintenance at this very moment until I can fully review the evidence. And I am happy to set the temporary order for a full evidentiary hearing on the parenting time and the financials, or get this case scheduled for trial in the next 60 days on the matters. I can't decide right at the moment whether or not this is a case for domestic conciliation. I doubt it's one for mediation, the way I'm hearing how things are going, but maybe domestic conciliation. So I'll leave that for you to consider. But I'm happy to give you a 90 day trial date. And if you're not ready for trial and you want to convert that into a more substantive hearing on matters that are covered under temporary orders, we could do that as well. Ms. Chrisman, I know that you are at a disadvantage. I mean, you've done an excellent job advocating for your client today. And, I think most attorneys explain to their clients that every other weekend or one day a week is pretty limited, restrictive visitation that's not common. And so I think they also will need to go to a parenting app if there's any pending cases or police involvement as well. Either Close App or our Family Wizard, whichever you prefer. But I do want to add one overnight, and that's just every other week. That's just twice a month right now. So I don't think they've gotten anything very, significant in the way of an alteration of what's been part of the temporary orders. But I do think there needs to be at least a little bit of a modification to that. Yes.
Apologies, Judge. My client had downloaded our Family Wizard if petitioner is open to it. I don't know that we can modify the criminal protective order, but I do believe he has a hearing on the 11th, and maybe if we're ready on that, we can get that rolling.
Yeah, I mean, I can approach his attorney in that case and see if we can get some sort of a modification to the protective order so that they can have that communication regarding the child only. I do know that the intention is to set that matter for trial because my client adamantly, denies that he should be prosecuted. So I don't know what's going to come about on May 11th.
Okay. I do want your client, though, since he admittedly is struggling with this divorce, I do want him to get a mental health assessment and find somebody that he can work with in some individual therapy. I think would be helpful to him while he works through all of this. I think that's important that there be an independent party that can notify law enforcement or the authorities if there's any belief that he is a danger to himself or others, which they certainly have a legal obligation to do, even if they're your therapist. So I do want to add that component as well as part of getting this overnight, that I am going to give them a little bit of time before it starts so that he can get an appointment with the therapist and either have seen a therapist or be seeing a therapist right around the time that the overnights begin. So we're looking at we'll start the overnight on May 16th. That gives him plenty of time to see a therapist. The reason I don't want to do the 9th is that's Mother's Day weekend anyway. So let's start on the 16th. And that gives him plenty of time to get an assessment and find a therapist. Okay? And then I'm going to modify the worksheet, which should result in some decrease in his child support obligation. And then we can revisit the maintenance if
The judge's handling of travel disputes exposes frustration with post-separation control battles. The father's side frames the out-of-state travel issue as a custody concern, but the judge hears something different underneath it: loss of influence.
we're not ready for finalization in 60 days. Okay? All right. So let's get a hearing date. April, May, June.
Judge, could I also ask one additional thing?
Yes.
Generally speaking, under the temporary orders, I'm not sure in Butler County, but in Sedgwick County, the parties have to agree if either one of them is going to travel out of state with the child, and that's not occurring. And my client would like to have some say on whether baby girl is going out of state.
Okay. So this is another approach I have philosophically. So when people are together, they have a child or begin a relationship or a marriage, bringing to the table what they bring to the table. And it's foreseeable for both parties to know that whatever it is they were doing before they got married and whatever they did during the marriage is going to probably be done after the marriage. And so if the travel is for family that was fair, I don't know what the travel's for. So you need to tell me if she's got a new boyfriend and she's traveling out of state, then yes, maybe that needs to be curtailed. But if she's traveling out of state because her kids are involved in softball tournaments, or there's a grandparent somewhere, or she likes to go to concerts or games or whatever, and it's something that she's done before and during the relationship, I'm probably not going to curtail that activity on her time, unless you can show me she's a flight risk with the child. But at any rate, what is this travel that you're concerned about, and what is it for, Ms. Chrisman? Do you know?
I do, Judge. My client was planning to go to Omaha with her child for her birthday to go to the zoo, but she's no longer planning to go.
Okay. Well, that would have been a fun trip. When is the child's birthday? I don't know if I have that here.
It's on Thursday.
Oh, okay.
And Judge,
Let's not be petty about things like that.
Well, Judge, I think my client feels like he was an active participant in making decisions, and now he's just been completely taken out of that. It's as though he's not an equal parent. I know there's joint legal custody, but that's not how things have been going.
Okay.
I do think that there are maybe significant others already coming around the child.
Okay, well, that just sometimes adds fuel to the fire. We don't do this in Butler County like Sedgwick County does, but I have seen pretty common orders from Sedgwick County where the judge asks that you not introduce the child to love interests for at least 6 months after separation. So the child can get adjusted to the fact parents aren't together. Parents are living somewhere else. Their schedules change. And just not have one more thing the child's got to adjust to and try to understand. And I'm kind of an advocate for that, especially in marital situations, and especially before people are actually divorced. So I would caution you to focus on your children. And it's hard, though, to communicate when there's no contact orders. So I'm hopeful that there can be a provision made for a parenting app. And I mean, I would be in favor of that because it's monitored. And that the parents would start communicating a little better through that app than probably what they've been doing since the separation. But yeah, I mean, they've been through this before. When you get divorced, you just have less involvement with your children, and there's a tendency for each parent to go about their plans in their lives, and there's not the same level of communication and agreement on things. But at any rate, I would ask that if she's going out of state, she simply give 48 hours notice that she is on her time taking the child somewhere out of state. And I guess that gives you time to come in and seek emergency order if you think it wouldn't violate the law. But if it is something that is serious enough that it should involve an emergency hearing or motion. Okay? All right. And I assume that the grandma or someone, or you can mail a gift and a present to the child for the child's birthday. And that shouldn't be a problem. Ms. Chrisman, do you know why either mailing something, having it delivered for the child, or grandma delivering it is problematic?
The conversation about new romantic partners quietly reveals another layer of judicial concern: emotional instability around replacement dynamics. Judges know divorce cases often explode once jealousy enters the picture.
No, and I believe that grandma's been very involved with exchanges and things of that nature, and so I think that would be fine.
Okay, very good. Well, she may be an important person to hear from down the road. But if you could also provide a list of property that he wants as part of the divorce that she has no interest in, or again, I go back to what is something the party used and sort of possessed as their own, what makes sense that is theirs, those kinds of things. Yes, there needs to be a value put on them, but there shouldn't be an argument about a lot of those personal items and who they should go to based on prior history of use and that kind of thing. So try to get that accomplished in the next 14 days if you can as well. And then I could do a half-day trial or an all-day trial if you think you'd be ready the week of June 22nd through the 26th. I'm open that week.
I have a 2-day trial on the 24th and the 25th, but if we could avoid that, I can squeeze something in.
Okay.
I have trial on the 22nd and 23rd, but I could do Friday, the 26th for half a day.
Okay. Let's plan on that. Do you want morning or afternoon?
Yeah, morning would be better for us, Judge.
Okay. Just keep me posted. We can always pull that and reset that as a final trial. We can use that as whatever we need to use it for. I don't know though, unless you contact me, that we need to do a status before then. So. All right, I'm just gonna put a half day reserve for them there. If you do decide that you're gonna use that as a full trial day, then we need to do probably a pre-trial conference or an order. By the 15th. Actually, that's not 14 days. If you'd waive the 14 days, we could do it on Monday, the 15th at 4.
Should be fine, Judge.
Okay.
I failed to do this in my last trial with you, Judge, so can I request that we have a deadline for the exchange of exhibits?
Yes. Amy, what's that new directive? Is that 14 days out from trial where it is? And just, I'm gonna ask that you submit to me on the 12th. So that's 14 days. It's not business days. It's 14 days prior to the trial. So on the 12th by 5, exchange, then that Monday, we'll have a pretrial conference. So you can be exchanging that information as you're working up a pretrial conference order, because you got to identify it in your pretrial conference order anyway. And so it can kind of be happening simultaneously. And then we can touch base at 4:00 that day, and then be ready for our trial on the 26th.
Judge, do you hold your,
I'm just gonna take that whole day. I'm gonna knock that whole day out for trial.
do you hold your pretrial conferences in person?
No, that's by Zoom, but I do the trials in person.
Certainly.
Okay, anything else today? Ms. Huntington, I would ask that you journalize this hearing, please.
I will, Judge. I don't think we have anything else today.
All right. All right, if there's nothing further today, we are adjourned. Thank you.
Sorry, I'm so sorry, Judge. I had one clarification.
Absolutely.
Does he need to provide proof of completing the mental health assessment and engaging with a therapist prior to the initiation of parenting time, or does the parenting time start the 16th?
I would hope that he could show either completed appointment or when his appointment is before then, yes.
Okay, thank
And
you.
I'd prefer that he be able to see someone. But it depends on the availability of someone and how fast their turnaround is.
The final section sounds procedural, but it actually exposes how serious the judge believes this case could become. Once the court reserves a full trial day and imposes exhibit deadlines, the hearing transforms from temporary conflict into organized litigation warfare. The attorneys are no longer managing emotions. They are preparing for evidentiary combat. The request for strict exhibit exchange deadlines also suggests prior distrust between counsel already exists. Then the hearing closes with another reminder about the mental health assessment. That final clarification matters because the court wants proof of compliance before expanded parenting fully begins. The judge is building a record carefully. If the father complies, the court can later justify expanding parenting rights. If he fails, the court gains documented justification for tighter restrictions. That is the real strategy underneath this ruling. The judge is creating a future roadmap while avoiding drastic immediate intervention.